But thank you for joining this week's Skill Up session, or Skill Up webinar with Small Business Women Australia. Thank you very much to Binh Rey from Baxter IP for giving up her time to run this session for us. We're greatly appreciative. I'll hand over shortly to Binh, who will run through her presentation. If you have any questions, if you could please pop them in the chat or in the Q&A section, and then we'll wait to the end for the Q&A section. But please feel free to pop them in, the questions in as we go, or feel free to write them down, and then we'll ask them at the end. So Binh, I'll hand over to you. Thank you so much.
Thanks, Rochelle. Thanks for the opportunity to present this evening. I would just, sorry, I'll just start from the beginning. Yes. Yeah, so just put this in.
Yep.
Okay, I think I've got everyone. Good evening, everyone. My name is Binh Rey. I'm a trademark attorney at Baxter IP. And I'd like to thank Amanda Rose for providing this platform to help small business owners to skill up on trademarking. And I'd like to thank Rochelle for organising the invitations to everyone and all the administration for this event this evening. So this evening, we are going to be talking about trademarking, and I'm hoping that everyone will take some practical skills away from them and to implement them in their business. So this is what we're going to go through this evening. So what is a trademark, and why are trademarks important? The number one and number two belief by the business community regarding trademark protection. Do you really need a trademark? And so we'll go through case studies that will demonstrate whether you would want a trademark for your business or not. And then we would also go through my top 8 tips to create a trademarkable brand, which will make any business stand out in terms of what they do. And the last thing that I would also like to touch on is when you do not need a trademark, because not everyone in business will need a trademark. And as Rochelle said, please feel free to put in questions in the chat line, and Rochelle will ask those questions out to me at the end. So let's begin. So what is a trademark? Well, a trademark can be a letter, a number, a word, a phrase, a logo, a picture, aspects of packaging, sound, smell, or shape. A trademark can be a brand for either goods or services, and there are 45 classes of protection. So these are the types of trademarks demonstrated by Coca-Cola. They own word marks for all of their brands, so Coca-Cola, Coca-Cola Zero. So as you can see, every time they add an extra word to a brand, they need to protect it. They've got slogans. One of my favorite slogans that they had was Coca-Cola Open Happiness, because it's one of their campaign basically was very successful. They had someone opening a can of Coke, and it was supposed to say that every time you opened a can of Coke, you were happy. And so therefore they thought that that slogan was valuable to trademark, and so they did, because they didn't want their competitor, Pepsi or any other beverage company, to use that slogan. You can also trademark packaging, design, and the logos, as you can see. So again, like the words, every time you change a logo, you also need to provide to obtain trademark protection for each change of a logo. So why are trademarks important? Well, a registered trademark is enforceable, is legally enforceable. A trademark is a valuable asset to any company. The trademark registration gives you the exclusive rights to commercially use and license or sell goods and services under that brand. And trademarks can be assigned or sold. So if you end up selling your business, it becomes a valuable asset that you can sell on to the new owner. Trademark registration facts. Well, trademark registrations are per country. So there's no such thing as a global trademark. So if you want a trademark and have protection in Australia, you trademark in Australia. If you feel like you've got to enter the US market, you must obtain a trademark in the US. Trademarks are for 10-year ownership. They're renewable every 10 years, and you can renew them forever. I looked up this evening. I think one of the oldest trademarks in Australia is owned by the state government of New South Wales. It is their coat of arms, and they registered that in 1850. A trademark must be used as a brand, or it can be revoked. So unlike domain names, you cannot own a trademark without actively using it. So you can't obtain a name, sit on it for 5 years, not use it, because someone can come along and go, I like that name, and I would like to use it as a brand. And if they can show that you have not used that trademark for that period of time, they can ask the trademark office to revoke it, and you will lose your trademark rights. So use it or lose it effectively. The trademark owner at the time of application must be used and owned by the correct owner. So if you start out as a sole trader and then you move to become a company, you must remember to transfer the ownership of that trademark from your personal name to the company name. Because without that, when it comes time to provide evidence of use, it would be in the wrong person's name or the wrong company's name. A registered brand must be used as it is applied for, originally applied for. So what I mean by that is, if you apply for, let's use Coca-Cola as an example. If they apply for Coca-Cola, but then they called it Coca-Cola Light, and they wanted to enforce Coca-Cola Light, but they don't own the trademark, well, that's not how they applied for it. They applied for Coca-Cola, and therefore Coca-Cola Light would not have any protection. Some of the symbols that you might see in the marketplace when you look at brands, the R symbol basically tells people that the brand is registered and is legally enforceable. TM basically just says to people, as a business owner, I'm going to use it as a brand, however, it's not registered, and therefore it has no legal rights. So TM effectively doesn't have any bite behind it. Many people use it just to, tell other people that they intend to use it as a brand, and therefore try to scare them off with the TM, but there's no legal rights behind that symbol. So imagine these brands not having any trademark protection. Amazon, it's the most valuable brand today. It's worth $315.5 billion. Apple is worth $309.5 billion. And then Google comes in third at $309 billion. And if they, and just remember, they all started very small. The brand was not valuable. And if they didn't actually own the trademark, that meant anybody else in their industry could have used their brand and piggyback on their success. So I've been doing trademarking for about 8 years now, and this is what I've found in the business community. The number one false belief by the business community is that they often tell me, I don't need a trademark. My company name gives me protection. And often it's the accountant that says to them, hey, here you go. Here's your PTY Ltd company name. Go ahead and start the business. No problem. However, that's not true. This is false. A company name, a trading name, a domain name, and trading history does not protect your company's brand legally if there is a dispute. And the number two belief is, surely ASIC would not allow another business to have a similar name to mine. Well, I can also tell you that's not true. So my client is Australian United Developments Proprietary Limited, and the other party was Australia United Development Proprietary Limited. So as you can see, it's 2 letters out, and they were both in property development and building, and you can't tell me that if you looked at it, glanced at it, that you wouldn't be confused about the 2 companies and who owned each of the brands. So let's run through some case studies, because the case studies want to show you some of the reasons why you would trademark, and you might see yourself in some of these situations. So let's look at Musashi versus Asahi. It was Nestle versus James Christian. In this case was in 2016. So as you can see, Musashi, owned by Nestle, and Asahi, and they were both in the vitamins business. And so unfortunately, James lost the court case, and these were the lessons learnt from the court case in terms of trademarking. So the judge said to James, you can't claim ignorance as an excuse, because James said, well, I didn't know that my brand was infringing on Nestle's. I've been trading for 5 years without any problem. Well, you can't claim ignorance. James said, I have a domain name and a trading name. I have a domain name and I've been trading for 5 years. Well, unfortunately, having a domain name and a trading name does not offer any legal protection for the business owner. The judge decided that it was too similar and the two brands would cause confusion in the marketplace. So James has actually placed the ruling with one judge about whether it's confusion in the marketplace. And the judge actually said to James, well, instead of leaving up to me at this stage, 5 years later, you should have attempted to obtain a trademark when you started. So you should have tried to obtain an Asahi trademark for vitamins. And if at that time the trademark office awarded you the trademark, then he wouldn't be in that position of having Nestle challenge him about the similarity in the brands. And on the flip side, if the trademark office also then said at that time, 5 years when he started, that his brand was infringing on Nestle's, then at that time, James could have made a decision whether he wanted to proceed with Asahi or not. He might have decided, oh, well, I don't want to get into any infringement with Nestle. I'll change my brand. And then he wouldn't have been in this position of losing the court case. And not only did he lose the court case, he lost his business. So his online business had to be shut down. He said to the newspaper, because he was crying foul, that he had lost his initial investment of $220,000. He had to pay Nestle's legal fees, and he had the stress of 18 months of going to court with Nestle. So this could all have been avoided if he had actually spent a bit of time at the beginning to research whether his brand that he started was going to infringe on another party's brand. So the lesson here is really, don't start a business brand without seeking trademark protection for the business or service, whether it's locally or overseas. The second case study is essentially use it or lose it. So in January 2019, Supermac took McDonald's to court in Europe because they wanted to enter so Supermac is an Irish burger chain. They wanted to enter the European market, and McDonald's trademark actually was stopping them from expansion. So they decided they were going to challenge Big Mac's trademark in Europe, and they actually won. They won the right to revoke the trademark, and the reason for that was that when McDonald's applied for the trademark, they applied for Big Mac, as you can see there, okay? But let's just see how they've used it. So this was the evidence of use. So they had Mon Big Mac, they had Le Big Mac, and then they had Le Grand Big Mac. So as you can see, McDonald's didn't actually use Big Mac in Europe as Big Mac. So they didn't use it as per how they applied for it. So in this case, because McDonald's Big Mac has been revoked, Supermac is planning to expand into Europe. And of course, because Big Mac is such a big company and multinational, they're challenging the court case, the judgment of having Big Mac revoked. So it's still going through the court, so it'll be interesting to see what happens. But as you can see in this case, even a big company can have their trademark revoked if they don't use it as per how they've applied for it, Okay, so again, if a registered trademark owner does not use their trademark actively as per the registered mark, it can be revoked. Again, trademarks are not like domain names. You can't pile them, you've actually got to use them. This case study is one that is that I like to share, because this client of mine, Your House, when he started the business, he didn't know that he needed a trademark. And by the time 2018 came, he found that there were 3 Euro House car servicing places with a similar name to his. And because of everyone going to Google searching for Euro House, he was finding that he was losing business to Euro House Prestige in Sydney. And he also had plans to franchise his business, because he was very successful in the northwest of Sydney, and he wanted to expand into other parts of Sydney. But he found that the brand was too confusing. So he bit the bullet and he rebranded, because he wanted a brand that was completely new in the marketplace, and that he would be the only one that would come up on Google search. He would be the first one to trademark it, and he would safely be able to franchise it this year and next year. So as you can see, the new brand EuroWorks, it is, if you type that into Google, you'll find that he's the owner of EuroWorks as a car servicing place in Sydney or anywhere in Australia. But if you type in Your House, you'll find that all 3 of those companies would come up. So EuroWorks demonstrates the best situation. You want to be a business that is first to use the mark, first to file the mark, because the protection starts when a trademark is registered. The protection doesn't start when you start your business. It's when you have it registered, okay? Okay, so, all right, case study 4. So this demonstrates that company name does not give you any rights to use the brand in the marketplace. A registered trademark is the only thing that gives you that right. And this example will show you the cost of rebranding can be expensive to business owners. So our client was an optometry business, and within 2 months of opening their iHub optometry retail shop, they received a cease and desist letter from OPSM's parent company. And when they rang us initially to say, hey, we've received this letter, do we have any chance in fighting OPSM? And when we looked it up, they had no chance, because not only did OPSM register trademark much earlier than when they started the business, but secondly, OPSM is using the mark actively in the marketplace. And therefore, it doesn't matter how good you are, you won't be able to overcome those issues in any court case. So OPSM gave them 28 days to rebrand, and they have rebranded. However, have a look at the rebranding costs. They told me it cost them $22,000 because they needed to have a new brand development, new logo, a new website, new signage. They actually had about 3 or 4 car wraps, and the car wraps are about $5,000 each, or up to about $5,000 each. They had staff uniforms, and they had to also rebrand all of their eyewear. Luckily enough, OPSM allowed them to sell through their existing stock, and now they're very happy with their new brand. And now that one shop is now expanding and franchising as well. But because they've got the trademark now and they were first to use it, they can, again, like EuroWorks, they can safely expand their business to other locations because they're protected for their brand. Indian accent, case 5. This is a case where an overseas competitor wanted to enter New Zealand, and my client was already there. And so what had happened was my client had received a letter from the Indian accent in India demanding that they stopped using the name in New Zealand, even though the client had been using it for at least 3 or 4 years, because they own the trademark in New Zealand. Well, actually, that was not the case. We found that the Indian accent brand was not trademarked in New Zealand. We then quickly applied for the trademark on behalf of our client. We told our client to delay the Indian lawyers because it does take 8 months to obtain a trademark. We were then successful in obtaining the trademark for the client in India, and now they're legally protected to use the name in India. They can now stop Indian accent from India from entering New Zealand. However, the cool thing about the whole obtaining the trademark is they don't actually mind if Indian accent goes to New Zealand. My client would be more than happy to license out that brand to them to use in New Zealand, because they're in Auckland and they're more than happy to have more restaurants with that name if they were willing to pay a royalty fee for using the brand. So as you can see, a trademark is very useful here, where it not only protects you, but you can also then obtain some revenue from it by licensing it out to other third parties. So those were the case studies to run through about the situations of when trademarking is important. So now let's look at what makes a great trademark. And these are my 8 top tips, which I've developed over the years. And with my marketing background, it will not only talk about registration, but also how you can protect it using marketing strategies. So first of all, if you're creating a new name, do avoid calling it descriptive names for your brand. So avoid descriptive names for your brand. And the reason for that is descriptive brands with words within an industry cannot be trademarked. So that's one of the rules within the trademark legislation around the world, is that descriptive words should be reserved for people within the industry to continue to use it as well. So no one can monopolize a descriptive word within an industry. Avoid copying an existing brand in the marketplace, okay? So if you see a brand that's either within your industry or a brand that's overseas but within your industry, do avoid copying them, because not only will you potentially have problems with trademark infringement, but you'll have copyright issues as well. And if you're going to start a new brand, you might as well try to be original instead of trying to copy somebody else in the marketplace. Avoid personal names or surnames. I think back in the 1920s to 1970, a lot of brands were started using surnames. So you can see that David Jones, department store, Smith's Chips, O'Brien Tires, I think, Bob T-Mart. So these are all using people's surnames or personal names. The laws have changed since then. It's not fashionable anymore, I guess, in many ways because of the law changes. But I can understand why before people using their name, because it gave them the badge of origin. Where did that product come from? And usually people would use their surname to identify the mark. But these days, as you can see, Google, Amazon, Apple, none of the new brands have got surnames in it. And they're in the legislation as well. Popular surnames are hard to obtain, and they're even harder to enforce. So as just a rule of thumb, do avoid calling your business using your personal name or surnames. Avoid using graphical location names. So, you know, like Bondi Beach t-shirts, you know, you're not going to get a trademark for clothing in that, for that, because you're using a geographical location name. So do avoid that if possible. Really spend the time to research and make sure that the name you've chosen hasn't been used in the marketplace, both locally and globally. It's not so it's not so bad if you're just going to be local in Australia. And if that's the case, then just make sure there's no local business that's already started. But if you're going to copy someone globally, you just want to make sure that they're not too big, because if they're really big, they'll have deep pockets and they might come after you because they can, okay? So it's best to, as I said, choose a name that's not used in the marketplace. Number 6, invest money with graphics designer to create a distinctive logo. It's no good going to $99 logo shop or I don't know, $5 graphics designer in India. You sort of want to spend the money to make sure your logo looks distinctive, and make sure that you know that you're not infringing on copyright issues if you're going to spend less on investing in graphics, a graphics designer. You should trademark the brand prior to starting the business, because it does take 8 to 12 months in advance. It's good that when you're about to start the business that you do look at filing a trademark for protection, and that'll give you the best position, as I said before, the first to use the brand and the first to trademark it. And it, you know, and when you think about it, it doesn't cost that much. You know, I think it works out to be about $200 a year over 10 years to have your brand protected. Ensure that you obtain domain names that are outside of the, you know, just one domain name. So usually you would try to get .com, .com.au, .net, .net.au, .sydney. There's so many out there at the moment. I'm not saying that you need to go and obtain everything, but just the key ones so that you can sit on those domain names, use them to redirect business to your main website. And it also stops other people from wanting to use it if you've got the desired domain name for your brand. So yeah, those are my top 8 tips to what makes a great trademark and a great brand. So what do you do once you obtain a trademark protection? Well, your company must police it. There's no such thing, there's no such organization called the Trademark Policing Department. Basically, the trademark owner is the person that needs to enforce the trademark. And if you're not willing to enforce your trademark, then in fact, you shouldn't have even spent money on trademarking in the first place. Because by not enforcing the trademark, you're allowing the person that is infringing to accrue honest concurrent use. And if they accrue enough honest concurrent use, they'll continue to be able to use that brand without you being able to enforce it in the future. So you must send a cease and desist letter to the infringing party if you find that they are using your brand, your registered trademark brand. So that's a really important point, because most people get a trademark and they forget that they've actually got to enforce it. I'll give you a demonstration of companies that sort of didn't enforce their mark. Some of these companies used to be trademarked, and now they're actually what they call generic terms. So when your brand becomes generic, it loses its trademark protection. So such brands as Thermos used to be a trademark. Now it cannot be trademarked without it having something else to go with it. Aspirin used to be a trademark, Escalator, Yo-Yo, Zipper, and Cellophane. So all these marks used to be a trademark, but because it became too popular and everyone's using it in the, you know, in the marketplace, that it's become generic. Okay, so this is a really good example, because Google has to be really careful, because in 2013, David Elliott took Google to court to try to revoke the trademark. And his argument was that Google is so generic that it's primarily understood as a generic term universally used to describe the act of internet searching. And he's right in many points, because many people go, I Googled that, I'm going to Google it. They don't say, I'm going to go to the search engine to find, you know, a company XYZ. Many people say, I'll go to Google to find something. So they they're using Google as a generic term. So Google has to be very, very careful that they can still demonstrate that the word Google is still used as a brand and not become a generic word like aspirin going forward. I've touched on this before. You must also ensure that the trademark registration being used is under the correct ownership name. So as I said before, sole traders usually would obtain the trademark initially in their personal name, but when they become a company, they must transfer the ownership of that trademark to their new company name, or else they could end up not having any evidence to show if there is any dispute. So it must be under the name of the company or the owner of the mark that is using it in the marketplace. And the best way of thinking about it is what is on your invoice? Is your ABN a sole trader ABN, or is it under your company? Okay, so it's making sure that that you have in the right ownership name. And also, if a company is sold to another party, you also need to make sure that the ownership goes to the new company as well. Because the worst thing would do is that you buy a company, the old owner still owns the trademark, which then gives them the right to then start up a business elsewhere with the same name. So what needs to be reviewed after trademark registration? Well, as brands evolve, you need to do a brand audit, okay? Making sure that the brands that you've trademarked is being used. Sometimes you might have to identify any gaps in trademark protection within your company. You might have introduced new products, but you haven't trademarked them. Maybe some product names have been superseded by new product names. So there needs to be an audit on the trademarking. And you might also find that maybe a logo has been updated. And therefore, because you updated the logo, you've actually got to update or reapply for the new mark. Ensure the ownership is up to date, as I said. And you also have to make sure that the trademark is renewed and it doesn't lapse. Okay, so when do you not need a trademark? If you're a business owner or an executive marketing person responsible for creating brands for your company, you receive a cease and desist letter, and you are happy to rebrand or go to court. Okay, so because those are the two options that you have. So when you receive a cease and desist letter, you have those two options, to rebrand or go to court. And if you're happy to do either of those, then you don't need a trademark, because that means that two things, that if someone told you to rebrand tomorrow and you're happy to do so at your cost, then they won't pursue you for trademark infringement. Okay, so those are the two situations when you don't need a trademark. And there are many sole traders that are in that situation where they say, well, I don't know what my business is going to do. And even if I am infringing, if someone asks me to change tomorrow, I'm happy to do it. Okay, so those are the situations. Other intellectual property protection includes patents. That's the protection of inventions and methods, such as engines, Wi-Fi, smartphones, fax machines. Copyright, that's the protection of content and creation of individual work. Domain is another type of protection. There's lots of domain disputes arising from trademark protection. And at Baxter IP, we offer the full range of services and all those intellectual property services. And that's it. That's the end. We've come to the end of the presentation, and I hope people in the audience have found it useful and have taken some practical tips away with them this evening. So feel free to contact me if you would like a free brand audit. And I'm also happy if you're starting a new business to talk about whether your new brand is trademarkable or not, and I might be able to sort of do a one-to-one advice on guiding you into the right direction in terms of launching your brand and making sure that the brand is safe to launch. So I'll hand it back to you, Rochelle. If there's any questions, I'm more than happy to answer them.
Fantastic. Thank you so much. Yeah, wow, Google, they've kind of become more too popular for their own good, haven't they? Yeah, that's now phrase, oh yeah, Google it. Okay, so we do have a few questions here from Sharon. Can you start using the TM symbol before you have the trademark?
Oh, yes, you can, yes. Because it's an unregistered right. So it's just basically giving people notice that you're planning to create it into a brand, but it has no legal protection.
Okay, fantastic. The next one is where to start with a trademark and how do I know if my business has already been trademarked?
Okay. There is a free search tool on IP Australia. So IP Australia, if you Google them up, they've got a free search tool there. And just be aware that when you do the searches, it's the most basic search that they allow you to do. So you would have to maybe do some of their tutorials to understand some of the more advanced searching that can happen using the IP Australia search function. So anyone can really go to the website to search on it. And I'm more than happy to, maybe if that person wants to contact me, I'm happy to send them the link.
Okay, that's great. That was Bree that asked that one. Okay, and Sarah, who is on here. So Sarah, feel free to chime in here. I'm building a platform, think TripAdvisor, but very different info. How do I protect my IP for the content and concept?
Okay, so in turn, to answer about the content is more of a copyright protection, and that differs from country to country. So in Australia, copyright is automatic, but in America, they recommend that you register it with the US Trademark Office. And I think I've actually got a table of the copyright protection. If Sarah's interested, I'm more than happy to share that table with anyone that is interested. So copyright really is different to trademark. So if her brand is like a TripAdvisor, what she will need to do is ensure she doesn't infringe on the copyright of TripAdvisor in the first place, because you wouldn't want TripAdvisor coming after you for any infringement. But at the same time, like TripAdvisor would have a trademark to protect their brand, TripAdvisor. So the second part of her brand protection would be to ensure whatever the new brand the name she's given to a new brand is very different and is not being used in her industry. And her industry is travel, accommodation booking, potentially transport. So it just requires Sarah to actually do a lot of Google searches on the name that she's chosen to make sure that no one in that industry is using that brand.
Thanks, Vin. It's Sarah here. Thank you so much for that information. I have searched. There is nothing with the same name. It is a different industry. So it's the same sort of venues that TripAdvisor would cover, but it's in the disability sector.
Oh, so okay. So it's like a review of, so will it be like available places in a nursing?
Along those lines, and different information that isn't available elsewhere on other platforms.
Okay. Even though it's not in the same industry, you just have, so let me just, it doesn't have to be the industry, it's more about the class. So if your thing is like a TripAdvisor and you're offering information online, the class protection that you're going to obtain is going to be very similar to TripAdvisor, even though you're in a different industry. So you still have to make sure that you've got to compare other similar sites that's giving information and booking to make sure that the brand name you've chosen is also not infringing. So in this case, it's not necessarily that you're in travel, but you're in a different industry, but the services that you're offering will be in the same class protection for the brand.
Okay.
Okay, so I'm just trying to think of an example that can be easily understood. Okay, for example, with retail, okay, retail. There's so many retail shops. You might have a department store, you might have a store that sells furniture, a store that sells toys. So it doesn't matter what you're selling in the stores, the class that you're going to obtain the protection for is the retail class. Okay, so that example is quite clear that you can be in different industries, but the brand protection you're trying to obtain is in the same class protection. So you need, when you do a Google, sorry, not Google search, when you do a trademark search, whether it's in Australia or around the world, you have to search it by class as well, not just by industry. Okay.
Okay. All right. Thanks for that. Is it possible to maybe have a chat with you outside of this?
Yep, I can point you in the right direction.
Wonderful. Thank you so much.
Dan, take a photo of the screen so you have Bin's contact details.
Absolutely.
Give her a call. Okay, we have another question here for you.
Yep.
What if the name of the company sounds similar to the competitor and yes, wants to build a connection to that original brand, e.g. TED Talk, and a new company is Gered Talk?
Not a good idea. There's been many cases where people have tried to jump on Instagram, you know, they might want to go Insta toy, Insta whatever. And what we're finding is that Instagram is going after a lot of companies, even though they technically have no right in certain industries, but they'll come after you. A really good example is, I've got two good examples actually. Chanel sued a chocolate company a couple of years ago in Adelaide because they were producing No. 5 chocolate. Okay, so they had No. 5 chocolate. And the reason we know all about it, because the chocolatier went to the, I don't know, Today Tonight or one of those consumer shows complaining that they were being bullied by a big company. Essentially, like I said before, even though Chanel does not produce chocolate, and technically, if they actually went to court, that chocolatier in Adelaide could have won the court case or could have won the argument that Chanel doesn't produce chocolate or they're not in the chocolate industry. But because Chanel has spent so much money on No. 5 brand, because it's well-known perfume, that Chanel wants to flex their muscle in any industry to basically to stop the dilution of their brand. So in that case, technically, like I said, the small business could have won in the court case, but are you really going to spend 20 grand to argue the principle? And at the end of it, you're not going to get much out of the 20 grand except a win. You won't get a trademark out of it. You might get some short-term publicity because it's Chanel, but ultimately, you know, in that case, just don't ever name any of your products No. 5. That's my advice. And then the other case that was recent was a lady calling her furniture refurbishment company Stalkia, and IKEA took her to court because she's trying to jump on IKEA's brand. And part of her business was, I think, to take IKEA products and making them look and refurbishing them to make it look really expensive. And so she, you know, in that situation, IKEA is a well-known brand, and all she's really done is added something in front of it and called it Sky Kia, and therefore that causes problems of infringement. So it's a complicated answer. Yes, you could possibly use it, but you're going to have the big companies. In the case of TED Talk, the owner of TED Talk will probably come after you.
Think so. All right, a couple more questions. Can a trademark symbol also represent or mean that you have applied for a trademark or a trademark has been filed?
Yeah, TM.
Yeah.
So TM says that you plan to use as a brand, and TM can also tell people that you're applying for it. No one can use a registered symbol unless you actually obtained a trademark. And if you're caught using the registered mark without having a registration, I think in Australia it's about a $6,500 fine by the government, but I guess they've got to catch you or someone's got to dob you in like anything.
Right.
If you use it. So it's actually illegal to use the R symbol if you haven't actually registered it, because you're basically telling people that, that you've registered it and that you've got legal protection when you don't.
Okay, so the trademark comes before the registered symbol.
Yeah, so the TM, you can use the TM safely anytime before a registered mark. Yeah.
Okay. Then this is the last question that I have, and then I'll open it up to see if anyone else has questions, is regarding the tip for avoid using geographical location names for a trademarkable brand. What if you have a product that is sourced from a particular location and you wish to use the location in the brand, for example, Mount Franklin Water? Would it be possible to trademark a location in this instance?
They've got these things called geographical indicators, and so there's been a big push from France, especially, like champagne is one of the geographical indicator trademarks, and so effectively they were able to prove that champagne product came from the Champagne region in France, and therefore they can only ever use that name because it indicates the location of where that product is being produced. But to obtain a geographical trademark, you have to have a very good industry body that lobbies for that recognition. But in general, if let's say so the Mount Franklin one, I think, was a controversial trademark to be given anyway, because I think there's been complaints that the water comes from there. So I can't really comment on it because I don't know the details, but I do know that there were complaints about it. But effectively, as just a rule of thumb, even if something is from a particular region, the best thing really to do is give it a, let's say if it's a winery, give it a distinctive name, and then you can always have that geographical location as a descriptor, but it doesn't have to be in your brand name, okay? So it can be, let's say if Baxter IP wanted to go into wines, we could get a Baxter IP trademark for wines, and let's say I grow my vines in the Hunter Valley, so I would trademark Baxter IP wines, and put the R after the wines, but then as a descriptor say it's from the Hunter Valley region. So it's not necessary to have the region's name in the brand. You can always have a descriptor. And that's what I often say to people, don't be afraid of a name that is not descriptive of what you do. Because if you build a good business, a good reputation behind that brand, eventually people will know what you do. So the classic example is Apple. I mean, who in their right mind would call a computer a fruit, But everyone today knows Apple in the computer world is a stylish computer that has a range of, innovative products, most desired, smartphones. So they actually built a brand behind that obscure name, And it's actually a very, very strong brand if you can build it. So yeah, so don't be afraid to use an obscure name, because ultimately, if you say it long enough, and you've got enough clients that give you recommendations, that brand will become a brand.
Yeah. Okay, well, that's all the questions that have come through the chat. If anyone has a question that they would like to ask, now's the time, so feel free. Wait, maybe we've answered everyone's questions. All right, well, I think that's it for the questions. Well, I'd like to thank you, Ben. It's been fantastic. I've definitely learned a lot, and I hope everyone has received the information, which I'm sure they have, you know, that they were looking for. I'd like to thank everyone for being part of Small Business Women Australia. Thank you for being part of the group. We're over 2,600 members now, which is amazing. So if you have any questions at all regarding your small business, if you would like advice on any aspects, please definitely feel free to pop them in the group. And I'm sure there's a wealth of information there in the group that other, you know, women in small business will be able to assist you with. So thank you. Also, we're having a survey to send out soon to gain some information about our group. So please, it'd be great if you, once you receive the survey, that you can fill that out and send that in. That will help us at Small Business Women Australia be able to determine the needs of the women in our group and be able to help everyone from that. So thank you so much, everyone. Enjoy the rest of your evening, and we'll see you in the group soon. All right, thank you.
Bye. Thanks, everyone, for spending your evening with me.
Thank you so much.
Okay, bye.
Bye.